grave suspicion, which was requested by the defense. Witness impeached. So we discussed witness supported, which we agreed to jettison yesterday because it hadn't been, no one had attempted to rehabilitate a witness in that manner. We didn't actually discuss tailoring of witness attacked, but tailoring it to the evidence, I didn't hear, thank you, I didn't hear anything about, I mean, certainly I've heard some intimations of bias generally, but I've not heard bias in the particular way that it's contemplated here. What are your thoughts, Mr. Samuel? I mean, I don't think it should be there is my point. I've not heard, while I've certainly heard general implications of bias based on parties' relative alignments with one another, I've not heard bias demonstrated in the particular manner that it's contemplated by this instruction.
The state agrees, Your Honor.
State what?
Agrees.
Just 1 second.
Sure.
I'm just looking at 131. You don't mind if we sit down, correct?
No, not at all. Yeah.
The original version had 3 bullet points. I'm trying to figure out what happened.
Right, but, well,
First
because
one's gone.
the first one's completely gone because nobody had any testimony about reputation for truthfulness.
Got it, okay.
And this one is highlighted because I thought it was a closer call because obviously parties are always going to talk about that people have biases. But this bias is supposed to be presented in a particular way, and I've not heard any such evidence.
I see what you mean. Okay, so instances of conduct of the witness, right?
Right.
I don't see that.
So my inclination would be to take it out, and the only one that would be in would be criminal convictions.
Right.
Excuse me. Prior statements. Okay, so Ms. Hilton, I had discussed with you yesterday this issue of immunity or leniency granted a witness. Mr. Samuel has made the argument that the case law is that the grant of immunity is so broad that it is essentially in service of any time that witness ever testifies about those actions, and therefore it's a relevant consideration. I had expressed yesterday that I wasn't sure if there was any particular case law on this point, but that at least from a plain language perspective, the pattern charge is written in a very, very general sense.
Question those for one moment.
Sure.
While they're talking, can I ask a question? Or I lost track of. Is what's on the screen going to be in numerical order, or are you skipping?
No, they're in the order.
So 13142, which is witness supported, is out. Witness impeached, one. So that's what's on the screen.
13145 is just the standard. This is what impeachment is.
Okay.
It's a little bit out of order because to me, you need to tell a jury how to impeach what it means to impeach a witness, and then witness attacked is there, but witness supported has been removed based on our conversations yesterday.
And you'd have prior statements.
Yep.
Okay.
And now we're on immunity.
Got it. Okay.
Your Honor, I didn't know if the court had a chance to consider the Lee case and what it. I think what's a fair characterization of the case law is that it is not error not to give the immunity or leniency instruction. We feel that in this case, this is really meant, and if you look at all the case law, and there's plenty of case law in Georgia with Lee and a bunch of other cases for the Supreme Court that say that it's not error not to give it. I think that we feel like that unfairly having its own instruction is an unfair emphasis on immunity leniency, which is a very, very minor part of this case, whereas it is adequately covered under the prior instruction based on credibility of witnesses, Your Honor. We feel like that having extra instructions in general runs a risk of confusing the jury. I don't know. This is relatively clear. I'll admit that, but we do feel like it unnecessarily highlights that. I don't think you need to give it. This is not the same thing. That is meant for a case where a co-defendant has got immunity. I mean, that's really what it is.
Right, we discussed that yesterday. I agree with you. That's typically where it comes up. Yeah. But it is written in such a general way. I will say this, though, to your point, Mr. Wilson, Mr. McDermott or Mr. Samuel, I mean, even if the court doesn't give that instruction, you're still allowed to argue that she got immunity for assisting her husband in murdering people, right? I mean, isn't that the argument you're going to make regardless of whether I give that charge or not?
Yes, but this is in the credibility of a witness based on being protected by the immunity, not that she's a bad person. This instruction deals with the fact that she was rewarded for testifying and is still under that protection. She's still protected by the immunity she received. If she
right, but it's not immunity in this case, is their point. And it does, so in theory, it doesn't, in theory, it would be lesser likely to influence her testimony here, I think is what the state is saying, because
there are so many parts of a jury instruction which, aren't the most important part of the case.
Sure.
I mean, all of this impeachment and witnesses and, are not critically important issues. They're just overall view of the types of things the jury can consider. Inconsistent statements. When you're talking about a credibility of a witness, why bother talking about inconsistent statements? Why talk about prior statements and stuff? It's because you're giving an overall view of the types of things the jury can consider, not required to, but can consider in evaluating the credibility of witnesses. I don't think we should take out something just because it's not error to take it out. We should only take out items that are just completely irrelevant to the consideration of the case here, like we've been doing with a couple things now.
okay. I'm going to look at it again. I did look at the general case law. I mean, again, I don't disagree with the state's assessment that this is typically intended for where a party in the case who's testifying has gotten immunity related to the case. And I also don't agree with you that the case law says it's not error to not give it, because you can still make an argument. Even if I don't give that charge, the defense can still argue.
Well, yes, Your Honor. I just don't think I think the case law is clear. It's not error for the court to instruct the jury.
But that's what I just said, right? I agree with you that it's not error to not give it.
Okay.
But I'm still not sure, under the facts of this particular case, that it's not implicated and that it would not be proper. So I'm gonna put a pin in that one and give you an answer in the morning. Okay. Single witness, defendant's choice not to testify, prior difficulties between the parties. So I would like to have a discussion on this topic because I think that although we have spoken in the generic about the prior difficulties that are alleged by the state between this defendant and the victim in this case, what I actually ruled was that those facts about those prior instances and allegations of physical altercation or abuse between the defendant and the victim were intrinsic evidence. And the law is clear that intrinsic evidence can be considered for any purpose once it's admitted. And this instruction says that the jury can only consider it to the extent that it demonstrates the state of feeling between the defendant and the alleged victim, which I'm concerned confuses the jury between the purpose for which they can consider it or not. Having said that, I also think that it might make sense to err on the side of giving this charge because the limited nature of the consideration might be better. I don't know. I do have concerns about it. I mean, as I said, the law is clear as far as I'm concerned that although prior difficulties, there is no case law that I can find that gives me a Venn diagram between prior difficulties and intrinsic evidence. There's some discussion in Carlson and some other things that, yes, the federal treatment of it and the state treatment of it are that prior difficulties are likely treated as intrinsic, but no discussion of the dueling standards that might apply. Because again, if it's intrinsic, then it's considered by it can be considered by the fact finder for any purpose. If it's truly prior difficulties evidence, then it's limited in the manner that is described in this jury charge. Thoughts?
Well, I think I expressed my thoughts yesterday that I mean, maybe it's protecting the court as much as anything. It is if, in fact, the court says some of this is intrinsic, some of it's not, some of it went back years, some of it, we don't even know what time frame they were talking about. If there was prior difficulties that were some of the earlier ones at one of the earlier Waffle Houses that goes, I think, before even July of '98, rather than being intrinsic, that may have been a prior, would fit more than the Venn diagram part of prior difficulties, and at least we're protected from that. The real point is we don't want a jury saying you're guilty of murder because of the way you treated her before. That's the whole point.
Right.
I mean, I don't even know with intrinsic cases it wouldn't be improper. I mean, there is an instruction much later on. You can only convict him with that with which he is charged.
Right.
It's really reiterating that in this context. What happened to 13400? Did we just skip over that? Or
130.
13400. It just says limiting instructions?
There is not a 13400. I think it's just the general proposition. Well, I'm sorry. Because there is no 404B evidence,
Of course.
there is no need for the general limiting instruction charge. I apologize.
It came out with all the similars, right?
Yes.
Got it.
Okay. So hang on. No, I've lost it.
There it is.
Thank you. So yesterday, the defense has requested this charge, and yesterday the state indicated that they didn't have any objection to giving that charge. I think there's probably a reason to consider giving the jury the charge, because whether it's, I mean, I've ruled it's intrinsic, but it is in the nature of prior difficulties between the two parties. And so if the state doesn't object to the defense's request that I give the charge.
What I'm trying to just think through is kind of what the court just said, because we have case law like Flowers v. State, in which prior difficulties between a party could be motive, or could be they're coming for other reasons other than
Because it's intrinsic.
right? And so,
Well, Flowers is a 404B case, to be clear. Well, there's two different Flowers, but one of them is a 404B case. It says even prior difficulties have to be evaluated under 404B. You don't get notice. That's the weird difference between
Right.
prior difficulties and 404B.
so then the question becomes: do we get 134.20 and go back and get 134.10?
When you find Hughes again, if it pops up, I can't find that citation for some reason.
Sure. So the purpose of the 134.10 instruction, as I understand it, and please, I don't want to make an error. If you think I'm making one, tell me. But the purpose of 134.10, as I understand it, is where you are limiting the use of that evidence. And my understanding is that when the court has ruled that evidence is intrinsic, i.e. necessary to tell the story of the murder itself, which, right or wrong, I have clearly ruled that that evidence was intrinsic, there is no basis to limit the jury's understanding or use of that evidence. They are allowed to consider it for any purpose to which it is relevant and admissible in the case.
You're right, so then we would ask for 134.20 not to be given, so it is not limit the purpose for which we introduce the intrinsic evidence of the prior difficulties of between Mr. and Mrs. Wolfenbarger. So
Okay.
we ask that you not get 134.20.
Okay. Mr. Samuel, your position is you do want it to be given, correct?
For sure.
Okay. Right now it's in, and that's gonna be my additional homework. Let me give you the Hughes case
Thank you.
before, now that I have finally gotten my history on Westlaw to pull up.
Yes. That's a different state. It's not better.
Very bad at navigating my history. Give me a few minutes and I will find it before we call it a day.
It's my responsibility. You had given me 296 Georgia something, and I just couldn't. And then I tried to search Hughes plus intrinsic and couldn't come up with anything.
Yeah.
But that's okay. Why don't we keep going through it?
Okay. Let me go back to my jury charge.
You guys are looking for a case that whole time.
Okay.
If you don't mind jumping back and forth, I just found Hughes for you.
Thank you.
312 Georgia 149. I believe that's the case you.
Well, I want to look because there was, the case I was particularly looking at was one particular prior domestic incident. And when I was just looking now, I found another Hughes case that involved 3 brothers, and I'm not sure that's the case I was looking at. So I wanted to find it again, but it was specifically related. It talks about both prior difficulty and intrinsic, and it was, the admission was specifically related to a prior incident of the defendant allegedly slashing the tires, I think.
Oh, I saw that one.
Of the victim.
I ran across that this afternoon when I was looking. It just didn't seem to be the same. Anyways, my issue. So no.
Okay.
So 13430, yeah, that's next.
Yes, and I have tailored it. Right now, the only evidence is evidence that witnesses have prior convictions, and so I've tailored it just generally to that. So we had some discussion yesterday about identification, and there was a discussion of whether or not to give 13510 or some portion of it. Obviously, the second portion of 13510 is very clearly directed at people who are, stranger observations of, wrongdoers, alleged wrongdoers, and that's not really what we have here. The more I looked at it, the more I thought, if we're not going to give that portion of 13510, is there really even any point to give 13510 when 13511 says it's the state's burden to identify this defendant as the person who committed the offense, which is really what's at issue in this case.
Yeah, sure. We were going to, I'm not sure if the state requested it, or we were going to withdraw 13510.
Yeah, I think it's pretty standard for the state to request both of them. And so, yeah, I will remove 13510 with everyone's agreement.
Yeah.
Okay.
On 13430, because there are no prior convictions against Mr. Wolfenbarger, because he just had misdemeanors. There was no felony against Mr. Wolfenbarger was introduced. And you said against any, well, what do you have? Just a witness?
Yes, it just says that
We're not a
it's
witness.
been tailored. You have received evidence of prior convictions of witnesses who testified in this case. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness and not for any other purpose.
Okay.
And then definition of crime, intent, no presumption of criminal intent, presumptions and inferences, malice, murder, motive, felony murder, causation in felony murder, aggravated assault with a deadly or offensive weapon.
Did you correct the typo in 21030?
I believe I did, where it said they, it now says he.
Okay.
And then there was some discussion yesterday that I don't think, setting aside for a moment the still pending DV motion regarding this issue of the offensive weapon. Do you have any, let's assume for a moment that I'm going to deny the motion for directed verdict and that the issue of felony murder based on aggravated assault is going to go to the jury. Typically, the charge of aggravated assault is accompanied where it's not like with a deadly weapon or a handgun where we all know it's a deadly weapon. It is accompanied by this charge, which I believe was requested by the defense. Any objection to that charge?
Are we talking 220, 23?
Yes.
Yeah, no objection.
Okay. Venue generally, the verdict, multi-count indictment. Alternates, etc. That's the entire charge. So I think, if I'm not mistaken, the parties are in agreement with the exception of the court's ruling on the immunity charge and the court's ruling on the prior difficulties charge, which, as it currently exists, the defense has requested, but the state objects to. Is that correct? Any other charges?
I am on the offensive weapon. That seems to me the same issues that are causing some concern about the directed verdict motion, why it doesn't apply to the jury instruction also. It seems to leave this so open they could decide that the act of dismemberment, the saw, was the weapon used, but that's not really in dispute. I mean,
I don't think so. I mean, I think the ME pretty clearly testified that those were post-mortem.
State must prove that the defendant assaulted another person with an offensive weapon
And caused the death.
actually injured.
I want to change this.
I mean, there's no display of anything to the jury. How is there any manner in which it was used? I mean, there's just no evidence of that at all. The character or capabilities of the weapon?
I agree, which I expressed during my discussions with Mr. Fawcett about the directed verdict motion, which is, like I said, even assume for a moment that I'm like, okay, it goes to the jury. I mean, there's literally no evidence of a weapon. I mean, I understand the state's argument when we were having the directed verdict discussion was, well, she died in a way where we've presented facts that, could lead, a reasonable inference could be drawn from those facts that she died by homicide. And so then I guess, and I agree with that, right? Which is why I denied the motion for directed verdict on the murder charge. On the murder, the felony murder, secondary, with the underlying felony of aggravated assault, that's what I'm still struggling with for purposes of instructing the jury as well, which is, how can a jury make a reasonable inference that a weapon was offensive if there's literally no evidence of a weapon? And I think I understand the state's best argument is that a weapon, in the very broadest sense, had to have been used to accomplish the death. Even if that weapon was, I think your example was poison or something.
Right, and not only that, but I mean, I think getting back to the root of the evidence that came out, the reason why we aren't able to make those determinations is because the state in which the body was disposed of, and ultimately, I don't know how that's not akin to essentially, not that the court would have that intent, but rewarding the defendant for doing a good job, making it difficult to make that determination. I think that there are facts and evidence. The judges, Your Honor, is going to give the jury a definition of offensive weapon, and it's up for the state to convince the jury that there is an object or enough facts and evidence that the jury can make those reasonable inferences that an object was used and that it fits that category that the judge is going to define as to what an offensive weapon is. I think that there is testimony from Dr. Gilbo, Dr. Terry, the investigator Miller, not just as the photographs, but the injuries, the manner in which they believe that the body was dropped off and murdered at a different location, that it wasn't sacked up at that location. I think all the facts in this case not just point to a homicide, but a homicide. We never said that she was killed with a saw, although that is still a possibility. She could have been. But we don't have the parts of her body that are necessary to make those determinations. And we don't have them because the defendant disposed of those parts. And I think that the jury has enough facts before it to make all those reasonable, common sense, logical deductions.
Mr. McDermott?
Hey, Your Honor, the state has to prove its case beyond a reasonable doubt from evidence, not from a lack of evidence. What he's arguing for is, court, please allow me some leeway so that I can prove this without any evidence. And if you don't, you're giving a windfall to the defendant because allegedly he hid the body really well and didn't leave us any evidence. That's not how this works. There's got to be evidence.
Well,
And you can't just say, we'll leave it an open door so that we can let them assume any possibility, like poison, etc. That is directly contrary to how this is supposed to work.
well, it seems as if I have some additional homework to do tonight, but I already did because I took it under advisement. But
Can I make one last correction?
sure.
This is nitpicky, but I think the statute warrants it. 13020 on direct and circumstantial. The last paragraph. You passed it.
13020.
You're right. 13020. The last paragraph excludes all reasonable theories of innocence. The statute says hypotheses. And I would request that be changed.
Okay. I will take a look at this. There are two versions of that pattern charge.
It came out of yours.
There are two versions of the direct and circumstantial pattern charge. There's the long version and the short version. This is the short version, number one. Number two, this has also been plain languaged by the plain language the pattern jury instruction plain language committee. So in an effort to get rid of big words and use words that are readily accessible is, I suspect, likely why hypotheses isn't there and theories is. But I will take a look at that.
Thank you.
Anyway, all I was going to say, and I don't know that I'm saying anything that I haven't already said, but to be clear, the reason that I'm taking under advisement is I've already said I think there is evidence here that is sufficient to require the jury to determine if they believe that a murder occurred here and that Christopher Wolfenbarger committed that murder. Where I am having some reservations that I think I've been pretty plain about is, while there are facts from which a jury might determine that a murder occurred and that Mr. Wolfenbarger committed that murder, aggravated assault requires that there be facts from which a jury could understand how that murder occurred and the manner in which it occurred. And that's what I'm struggling with, because there is no evidence of that. And the mere fact of death, I understand the very broad way in which the state wants me to interpret the aggravated assault standard, but I haven't finished looking at it yet, but the defense is at least urging that the broad way that the state wants me to interpret that aggravated assault isn't as broad. They're not actually allowed to have it interpreted that broadly because, for example, and again, I'm just saying this is what they've argued yet because I haven't had a chance to spend some time with it, but that other methods of aggravated assault are not available to the state, like aggravated assault strangulation or other things. And yeah. Well, that's why I mentioned it, because I don't know that I'd heard a clear response from the state on that point.
Well, I would like to pose a hypothetical to the court, for the court to consider. I think may. Well, let me, if I could.
Sure.
So I would say let's say we have an example where an individual is found deceased, and they have a significant injury to, say, their head, and you have another individual that just no other evidence, but they confessed to it. I did it, and you don't have any other facts but that. You ultimately would have evidence not of an object. You wouldn't have evidence of a weapon that was used. All you would have at that point is the confession tying the person to the crime, the injury, the death, and then you would have the injury itself. That's the only thing that the state is missing in this case, is a visual depiction of that we could say definitively where whatever impact happened. So we don't know if it's bruising on the neck. We don't know if there were hand marks, that she was choked, and that because of the state of her, we don't have the marks on her neck to show the jury, hey, this is why we believe she was deceased or asphyxiated because she's got these marks on her neck.
So, forgive me for interrupting, but two things to your example. Number one, I'm not sure I agree that that example is apt here, because if you had a significant head injury, like, for example, if the skull in this case was distended in some manner or injured in some manner, then the existence of the injury, right, could be used as some evidence of the offensive nature of the weapon that was used to cause a violent injury or an attempt to cause a violent injury. And that is not, that's number one. But number two, and my real point is what you just said, which is you've mentioned a couple of times whether there's bruising on the neck or if they use their hands around the neck. What I haven't gotten a clear answer to from the state is a response to the defense's argument that ag assault strangulation is a different crime that is not charged in this case, and the state can't argue it.
It is a different crime, but aggravation strangulation can be charged with regular aggravated assault. It can specifically be charged with aggravation strangulation. And the state would be authorized to make all those arguments and close an argument. So I don't think that specifically charging it with family violence aggravated assault or aggravated assault strangulation prevents the state from charging the cases as a plain language aggravated assault in both of those instances and still prosecuted for the jury. So I don't think that charging it specifically as a strangulation prevents us from arguing that that's one of the possibilities that you could have been murdered or one of the matters for death. The charge of aggravated assault is meant to be brought, especially when there's an issue as to the date in this case. There is an issue as to the date, especially when there's an issue as to being able to prove what type of object. We're going to have this issue anytime there is the lack of evidence because of the actions of a suspect or a defendant. This is always going to be an issue, but that is why the statute phrases the options as offensive weapon per se, and it specifically relates and mentions objects because it says objects because there are limitless, depending on how the objects are used, it could become dangerous and cause serious injury. And that's the point that the state's making ultimately is that this is not like any other situation where you have pieces of evidence that's missing. The jury has the facts to make those conclusions based off of all the facts in the case. The injuries that occurred before, the injuries that occurred throughout the year, the manner in which her body was disposed of, the manner in which it was assaulted and cut, dismembered, and I think that all of that is something that the jury should be able to consider in that determination as to whether or not the state met its burden of proving felony murder.
Okay. So, just to be clear, so I know what my homework is, I'm going to look at the immunity charge. I'm going to look at the prior difficulties charge, the theories versus hypothesis in the circumstantial evidence
At
charge.
least mine's easy homework, okay?
And I already have under advisement the DV motion on the ag assault felony murder. And I will say this, if I allow that charge, that count to go to the jury, I expect that what I will do is give the patterns that are here and let everybody argue about what the questions that those patterns beg, right, that the state doesn't have answers to, that I've heard from the defense. So.
Your Honor,
Yes, ma'am.
I am looking or researching. I know that we've had some statements come in, prior inconsistent statements come in. I know we have the prior statement charge that rules of credibility, but specifically that the prior inconsistent statement can now come in as substantive evidence, and so that they can take what the prior inconsistent statement was as fact or as substantive. And so I don't believe that the prior statements charge adequately addresses that. So I'm just trying to, and we don't have a pattern charge on that specific topic, so I may be emailing the court a
Okay, that's fine.
non-pattern charge. So just,
Okay. I mean,
I looked for a prior inconsistent statement with the substantive portion. I didn't.
but that's, I mean, that's because it's a relevance ruling, right? Prior inconsistent is whether it's coming into evidence because it was disputed. And I believe those statements are in evidence, right? So the question is to tell the jury what to do with them. And I think the issue is go back and look at the prior inconsistent statement, or excuse me, the prior statements charge. I think that the pattern discussions indicate that it was intentional to do a broader, more general statement about the purpose of prior statements. And if you look, it doesn't say that you can only consider it for its, inconsistency. It's for you to decide why they would have said one thing before and said something else now. So I believe that that's why there's not a pattern that specifically highlights that it wasn't inconsistent or not inconsistent, et cetera. But if there is other language you want the court to consider, I will, of course, consider it.
Thank you.
Anything else from anybody before we adjourn for the day? Okay. I will see you guys in the morning at 9:30. Yes, ma'am.